Good afternoon, Commissioners. This is Troy, your host. We are live and recording.
Good afternoon, everyone, and welcome to our Tuesday, October 24th Board of County Commissioners Land Use Meeting and Public Hearing. I'll call this meeting to order. If you'll all rise and join me in the Pledge of Allegiance, please. I pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Thank you. Attorney Garcia, do we have certification of today's agenda?
You do. The County Attorney's Office has reviewed all items on the agenda. All items have been appropriately provided notice, and you have jurisdiction over all items.
Thank you. And do any commissioners have disclosures for items on this agenda today?
I have none, thank you.
No, sir.
And I have none either. Moving on to item 2, land use meeting agenda items. We have no items under that category, so we'll move on to item 3. Our public hearing agenda items. We have one, item 3A, Canyon South Preliminary Plan Number 2, Project File SB 2023-010. Eric Pavlinek presenting for staff. Hi, Eric.
Good afternoon, Commissioners. Eric Pavlinek, representing Planning Services. The item before you is Canyon South, Preliminary Plan Number 2. The project number is SB 2023-010. Richard Cross and Chad Murphy of Hines are here as the applicant. Al Cunningham of PCS Group is here as the applicant representative. The request is for approval of a preliminary plan for 155 single-family detached residential lots, 1 super block lot, 5 tracks, and associated public roads on approximately 494 acres in the Canyon South Plan Development. The intent of the preliminary plan is to provide an in-depth analysis of the proposed subdivision, including a review of the design, considering the ability to obtain water and sanitation, identify geological hazards, environmentally sensitive areas, wildlife habitat areas, source of required services, vehicular and pedestrian circulation, storm and drainage, and water quality, relationship to surrounding land uses, and conformance with the master plan. The preliminary plan process begins with the submittal of an application. Following comments by staff, the request is forwarded to referral agencies. At the beginning of the referral period, courtesy notices are sent out to abutting property owners. Public comment was received from adjacent property owners within the development. In general, public comment focused on the revised lotting pattern, traffic, decrease in open space behind existing homes, water, and impacts to wildlife. All the correspondence received is included in the staff report. Public notice is then provided, and the request is heard by the Planning Commission prior to consideration by the Board of County Commissioners. The Planning Commission considered the applicant's request for approval at a public hearing on October 16th. 2 members of the public testified in opposition of the lotting pattern next to their homes. They indicated that they paid a premium for open space lots and object to the plan, which establishes homes closer to the backyards. The applicant indicated that the separation between lots will be approximately 78 feet. They were not aware of what the home builders may have told the home buyers. The Planning Commission clarified aspects of the plan regarding preservation of historic silos and county acceptance of the traffic impact study. The Planning Commission felt that the approval standards had been met and recommend approval of the preliminary plan application subject to the 4 conditions proposed by staff by vote of 6-0. The site indicated by the red star is located northeast of the town of Castle Rock along the southeast side of Crowfoot Valley Road. The site in red is zone PD plan development or PD. Finally, an aerial view of the preliminary plan boundary in red. As background, the PD was established in 2004, and the first preliminary plan and final plat were approved by the board in 2006 and 2007. Various plats have been approved in the intervening years. A total of 633 lots have been platted within the PD thus far. The current request will amend portions of platted lots roads, and tracks within the development, in addition to establishing new lots and tracks. The current request conforms to the Canton South PD 8th Amendment, which was approved administratively in August of 2023. The amendment adjusted planning area densities, and the golf course use was then converted to natural open space. The amendment did not increase overall density within the development. This slide shows the overall preliminary plan boundary in yellow. As stated, the preliminary plan will amend platted lots, tracks that were previously platted, along with establishing new lots and tracks. Following our site photos, this is a view from Furvid Street looking northeast. Same location looking east. And then finally looking southeast. The approval standards for a preliminary plan requests are set forth in Section 403 of the subdivision resolution and are listed on this slide. Staff's assessment of the approval standards are noted and discussed in detail within the staff report. Should the board find that the approval standards for a preliminary plan are met, the following proposed conditions should be considered for inclusion in the motion. Condition number 1, during construction activity within the development, the applicant, its successor, and assigns shall take all reasonable care to watch for historic resources, paleontological resources, and other cultural history resources, and shall immediately notify Douglas County and complete appropriate Colorado Office of Archaeological and Historic Preservation data management forms in the event of such discovery. Condition number 2, during construction activity within the development, the applicant, its successor, and assigned shall conduct a burrowing owl study if any earth moving will take place between March 15th and October 31st. Condition number 3, Colorado Parks and Wildlife literature shall be made available to both prospective homeowners and home buyers regarding the existence of wildlife in the area and how to minimize conflicts. Condition number 4, technical corrections to the record copy of the preliminary plan exhibit shall be made to the satisfaction of Douglas County. And condition number 5, all commitments and promises made by the applicant or the applicant's representative during the public hearing and or agreed to in writing and included in the public record have been relied upon by the Board of County Commissioners in approving the application. Therefore, such approval is conditioned upon the applicant's full satisfaction of all such commitments and promises. Section 405.08 of the subdivision resolution sets forth the parameters of the board's determination on the preliminary plan request, which is noted on the slide. This concludes my presentation. I'm available for any questions. Otherwise, Alan Cunningham and Chad Murphy have a presentation.
Okay, thank you, Eric. Any questions for staff?
So Eric, I also read in the packet the same comments that you talked about that were brought up at the Planning Commission, that people said Taylor Morrison sold them their lots and that they paid a premium because there was going to be open space behind them. I'm just confirming that that's what you said as well.
Yeah, that's correct.
So is there any way to follow up and see if that really is true, that if people really did pay premiums for their lots? And if not, I'm just wondering, I mean, I read it from several different people. And if that's the case, that's blatantly unfair to those property owners if in fact they paid a premium for their lot when they were told it was a open space behind them when it was clearly platted years ago. Maybe I should ask the county attorney.
I think we'd have to rely on those statements from those individuals at this time.
Okay. You know, okay, thank you.
Thank you, Commissioner Thomas. Commissioner Teal?
No questions.
You know, I share, I think, the tone and tenor that Commissioner Thomas is indicating to you, and I think as a, commercial real estate attorney for most of my career, I'm always a bit concerned about the estoppel issues, and when individuals rely to their detriment on representation of others, and, that leads to damages. So, again, I think I would like the answer to that question as well. I also sit on the Centennial Airport Authority Board and want to reference the letter that they drafted about the noise study and the avigation easement. And I also sit on the Cherry Creek Basin Water Quality Authority. But let me start there and make sure, is somebody here from engineering?
B.
Okay, from our staff. I just want to confirm, normally it's Ryan Adrian that I work with Cherry Creek Basin, but I want to confirm that the Reg 72 requirements have been met. I know at this time the Cherry Creek Basin refers those issues to us.
Al Peterson for engineering staff. Yes, Commissioner, those Reg 72 requirements have been met.
Okay, great. Well, thank you for that. I think that solves one issue. I will reserve comments on the avigation easement issue until I've heard from the applicant. But if the applicant wants to come forward, state your name and where you're from, we'll be pleased to hear your presentation.
Good afternoon, Commissioners. While Eric's pulling up the presentation, my name is Alan Cunningham with PCS Group, 200 Calumet Street, Denver, 80223. On behalf of the ownership group, Hines, I'm pleased to be here. I'll give you a brief presentation since Eric did such a thorough job in his staff report and with his presentation. And then additionally, we have members of our team here as well.
Yeah, thank you.
Speaking of those members, and as Eric mentioned, both Chad Murphy and Richard Cross with Hines are here, as well as our civil engineer, Brian Moss with Cover 3 Engineering, and Allison Alteris with Otten Johnson, our land use attorney. So at the county's request, this preliminary plan, number 2, is bringing up before you primarily to accomplish 2 things. First, to make the plan current with the removal of the golf course and associated net increase in open space and memorialize the prior platted lots that have occurred over the past few years, and then also to represent the next 155 lots proposed within this next phase. On this plan, there's 2 different graphics. The one on the right that has the colored hatches, the blue, green, and orange, overlay the previous filings, what were within preliminary plan number 1A, and then the plats that have been associated with that over time. And then the image on the left shows it's a little hard to see the darker lots there and there are the 155 lots that are within this preliminary plan, and then all the other lots you see in gray are those ones, 633 of them that have been platted over time. So this slide just represents where these 155 lots fall within the preliminary plan. So this is overlaid on the currently approved preliminary plan, PD Amendment number 8, showing in combination in PA3 where those lots sit, and then in PA 4 and 10 over here, that these lots are contained within the current boundaries of PD Amendment number 8. Zooming in a little bit, and similar to the slide Eric had showed, the lots are hatched on here in that rust color showing where they sit. And again, the area in yellow is the boundaries of this preliminary plan, but as you can see, everything essentially to the north of these lots is a super block. The parcels are overlaid on there so you can see planning area 1, which is one of the large future parcel. So a future preliminary plan and plats will define the proposed lotting. There'll be 180 units remaining after this preliminary plan within the allotted 968 units that are allowed within the Canyon South PD. And then also on here, you can see the green hatched area is one of the other things as part of this preliminary plan is we've spread out the parks a little bit. So while still meeting the obligations within the PD for the amount of park space, anyone who's been out there realizes it's a pretty big site and things are spread out, and so just a better distribution of park space within the community. So this slide zooms in even further, shows those same 155 lots also hatched. As you know, with the 968 permitted lots in Macanta, that has taken time platting over the years to get to this point. And during this process, the removal of the golf courses occurred and the water conservation benefits that come with that. But also part of the goal has been a consolidation of lots to improve efficiency, disturb less land, increase open space in association with that, and just kind of a modernization of lots for what the builders are currently demanding. And then also to just respond to water conservation methods and Castle Rock water, smaller yards, since they're not going to have a bunch of turf and other things in them. So we've consolidated those. And then importantly, the PD boundaries are shown on this. That's in conjunction with these two parcels, it's the thickened red line that you can see around them. So you can see that these proposed units are all contained within the planning areas of the approved 8th PD amendment. So in summary, again, 968 total units approved within the Canyon South PD. This preliminary plan is memorializing the next 155 lots at Macanta Canyon South. The application is consistent with the currently approved PD amendment. We're offering better park distribution within the community as part of this preliminary plan, and there's increased open space within that preliminary plan area that was actually memorialized in that last PD amendment that was approved a few months ago. And then at this point, as was mentioned in the staff report and brought up, there was some public comment both in the staff report and at the last hearing. So I'm going to turn it over to Chad Murphy with Hines to discuss that topic.
Great, thank you. Mr. Hines?
If you want the pointer, it's the middle button.
Thanks, all.
And I mean Mr. Murphy at Hines, sorry.
Good afternoon. Chad Murphy with Hines on representing our entity HT Canyon South Development LP here. I just want to start off by saying thank you for the time. It's always a nice opportunity to come before you, and we appreciate this. And so we've been before you a few times now, and I wanted to personally come here today because of what we heard in Planning Commission last week as it relates to some of the adjacent homeowners. But before I get there, as a reminder, we bought this property back in 2018, and the PD for the property was largely in effect at that time. We appreciate the county commissioners sort of honoring that PD throughout the life of this project. We've built approximately 350 homes so far, so about a third of the way through the 968 lots. If you haven't been out there, it's a wonderful property. The project is truly one of a kind in our opinion. The amount of open space per individual unit, it's like one home per acre. We've deeded over 450 acres to the of parkland for the regional park. And we really kind of just done what we said we were going to do from day one. So I do want to say thank you for that. This preliminary plat or preliminary plan that we are before you on today is really the extension of the next phase of development, which is these 155 lots. So we hope to be under development on these here in the coming months. And it's really just the next phase and kind of marching along. And so I want to kind of go back because I was probably the only one here when we bought this property in 2018, recollecting of what was purchased. And back then in 2018, when we stepped in and kind of took over a defunct project, there was an existing plat that dated back to 2007, as Eric had mentioned. And that plat consisted of sort of bigger, larger custom lots with a golf course sort of thread throughout. And that plat existed. I mean, that property went and was platted by the previous owner. When we took over, the PD had since been amended after that plat to sort of reconsider what this property could be. And then we bought the property based upon that PD that was subsequently done right before we bought it. So we relied upon that PD. And effectively what that did was alter some of the lots and consider this more of a master plan community based on open space and not kind of higher end custom lots, if that makes sense. So we replatted the first 343 lots in our first phase, and that was effectively replatting those big custom lots. That plat was done in 21? 2019. So shortly after we bought it, 2019, we replatted the first phase. And the intent was to always subsequently move through replatting those existing lots into the more corrected version or the updated version of the PD that we purchased the property based upon. So I just think that's an important kind of anecdote of how this property has been developing over the years. And so we have heard some of the concern from the residents. Sounds like we might have some of those folks here today, and we can have a discussion about that. I don't want to get into what premiums were paid because we're the developer, we're not the home builder. But what I do know is that premiums have been sold by almost every single home builder, no matter what the lot type exists, whether it's an internal lot, an external lot. So then you get into discussion about gradient of premiums and how much premium was paid based on what type of lot. That I can't speak to. I do know that even as it exists today, what we've proposed, these lots are still all open space lots, adjacent other open space lots, and so we are honoring that in this sense. But again, I don't want to get into what Taylor Morrison may or may not have done, but I think that would require a deeper dive if you were to go there, because I think that how much a premium was sold is probably contingent upon the type of lot, when it was sold, what the market was like, how much open space versus any other open space. There's a lot of factors there in that consideration. But as it relates, I don't know that that's really a topic that we can dive into. What I can explain more clearly is that this plan that we've put before you, this lotting plan, adheres to the PD and is exactly what we had intended to build from day one. This map right here, in fact, is a map of the master plan community of the overall Macanta project that has been posted on our website for the overall project back since 2021, and that is unchanged, and it represents the lots as you see them in the plat today. So I want to just make that point clear that we've kind of been here, and we want to be respectful to our residents, because driving around the community and seeing residents now existing, or the homes existing with residents inhabiting those homes in this community, it's a great source of pride for me, and I think for our company too, because it's a wonderful project. So I think I'll probably leave it at that, and if there's any questions, I'm happy to take them now.
Great, thank you so much for that. We appreciate the applicant providing that information for us. I'll say anecdotally too, just from a one commissioner standpoint, I mean, what a beautiful development. I mean, Canyons has just become a remarkable and iconic. A lot of my meetings are at the Exchange, so I know you've done a really good job at trying to create an aesthetic out there that is impactful and positive for our citizens. Let me open it up for any questions from our board.
So I'm wondering if somebody from the development might be able to point out where these new lots are and the lots that conflict, or from the people that have said they bought premiums. Do you know which lots we're talking about here?
So it's generally in this area, Commissioner, where these are the platted lots where residents have moved in, and it's this portion of PA3.
Okay. And
So
if
there is a proposed open space between with a trail connection. There's a slight draw there where drainage would come down, where in one.
I should step in. I forgot to make the key point. My approach? Yeah, all right. I forgot to make a really key point. That was the whole point of me being up here, but it's different when you rehearse and you actually are standing before you. The point was, and it's critical, is that we had looked at, since last week's meeting, an opportunity to try to respond to what we heard from the residents. And which one is the dot?
The middle round one.
Okay. So this right here is a school parcel that we intend, or have we already deeded it to the school? We deeded this acreage to the school district. Given the new layout, we think that there's a potential, but this needs to be proven up, to possibly move 1 or 2 lots to this approximate location where I'm pointing, and thereby moving these, essentially relocating one or two of these lots here. That would allow this entire cul-de-sac to shift up north, further away from these homes here that I believe are concerned. To the extent, we're not totally certain yet, it looks like anywhere from 30 to 70 feet, based upon engineering and what can occur. So that's something that we can commit to looking at and potentially doing an adjustment, as long as we can get the school site or the school district to kind of work with us on relocating that. We've heard that this is more than enough land for them as a school site. So we will make the commitment to study that from an engineering and feasibility standpoint at the time of final plat. And I wanted to make that key point that we will look at that. Obviously 1 week is not enough, but I do think by the time we get to final plat, that's something we can do in that stage. And I believe it would fall within the rights of still approving the preliminary plan today, but then having the ability to try to make that happen. So that's the key point I forgot to make. So thank you.
So if you could just orient me then, because I don't see a north arrow on here. It's not like these homes will be in the view of the mountains, because the mountains are the other direction. Is that right?
That's right. Mountain views are this way, south, down,
Okay.
and to the
Okay.
left, if anything.
Thank you. I don't have any other questions for you. Thank you.
Thank you, Commissioner Thomas. Commissioner Teal?
No questions. I appreciated the applicant's responses there.
Well, I would agree with that. It's always a positive when the parties can work through challenging circumstances, have those meetings, and identify a zone of possible agreement when there are those conflicts. So I appreciate that. I want to go back to the navigation easement issue. And, I saw in the referral comments that Centennial Airport asked for a navigation easement and some work on noise. I'm a little concerned that it seemed to be dismissed by the applicant. And again, the rationale is pretty obvious. I mean, people, especially in this economy, are trying to qualify for whatever they can get into when they buy a home and get to closing. The average residential home buyer is not going to be piecing through every single jot and line and item throughout the closing documents, and oftentimes don't do that with an attorney. So they're going to buy a home, and then 10 years from now or 20 years from now, this Board of County Commissioners or the Board of Centennial Airport is going to have to hear from citizens like they are now in Greenwood Village about noise and dust and sound and flights overhead and things of that nature. And right now, I mean, there's litigation being threatened. This is all public information with citizens in Greenwood Village and the Centennial Airport Authority. So part of my job and what I want to do is head off those future conflicts by just providing notice and some form of support for the $2 billion general aviation airport just north, so that they're not subject to some form of lawsuit in the future when citizens complain. The other issue is when there's a purchase of a home, they get into it and suddenly they can hear everything happening outside. So the noise issue is significant, and I think, having construction materials that prevent some of that noise from interfering with the quiet enjoyment of a property is pretty significant. So if the applicant could speak to some of those issues, I think I'd appreciate hearing that.
Yeah, I might call upon some help here, but Chad Murphy again. Commissioner Layden, I believe we've talked about this in the past, and I wish I had the exact discussion we had before now, because I know we've talked about it and we reconciled it. But I think, in short, it's not a requirement. We've certainly studied it, but in terms of the distance that these properties are in relative distance to the airport, it's not a requirement from a legal standpoint. And we have not heard many complaints about noise. I mean, certainly there's aircraft in the area. I mean, I've been on the property many times when there's been flights over top, but it's never been a concerning issue. And so I don't know if we have a legal answer, but it just hasn't been a concern. And I think we've reconciled this in the past, and I don't know exactly what our discussions were in previous hearings, but I know we've talked about it.
We have, and I'll try to be consistent with my issues, and maybe we can work together to find where we landed in terms of reconciling that issue. But in their correspondence from the 16th of this year, they say the proximity by the airport is directly under the instrument landing system, the ILS approach to the airport's main runway. On elevated terrain, it can see overflights at all hours of the day, regardless of weather conditions, with aircraft of altitudes of 1,000 feet above ground level or less. It's a precision approach, can't be deviated from by aircraft when it's in use. So at least from the airport, and it's Samantha Bleimer, the planning specialist with Noise and Environmental there, that drafted this letter.
Yeah, I don't know that we can do much about that, unfortunately, Commissioner. I certainly don't want to encumber the property with a new easement that we really haven't needed in the past. So I don't, do we have anything more to say on this?
Hi, Commissioners. Allison Alteris with Otten Johnson, 950 17th Street, Denver, Colorado, 80202. We did look at this in response to the referral comments, and our determination at the time was that the property is not within the area that is required to record an navigation easement, and the navigation easement has not been recorded on other portions of the property that have developed, so we were advising our client to take a consistent approach with this one. That being said, I don't know that there's resistance to making disclosures or anything to that effect. It was just consistency throughout the development as to recorded instruments. And in our view, I think particularly with respect to height restrictions and things like that, that the PD is restrictive enough to accomplish, I think, what the navigation easement would otherwise be intended to accomplish. So that was our view of it, but I suspect that there's willingness to consider disclosures, whether it's in contractual documents or elsewhere.
Thank you for that, Counselor. And that depends on my board. I think I'd need to have support for any additional work on this. But again, there's a recommendation for there to be a verified interior noise attenuation at or below 45 decibels. And they're recommending a residential 7-day noise test. And so to Mr. Murphy's point, what can you do? I think a navigation easement and a noise test are what's being asked for, and those aren't incredibly intrusive or difficult, I wouldn't think. And part of it goes to Commissioner Thomas's earlier point of just putting people on notice before they sign the dotted line and close as to what's happening. And it's avoiding the complaints and the litigation in the future.
So I just want to, I'm looking for these pages. I thought when I read this last night that someone had drawn little boxes on the documents from the airport that said that these lots were not in the area that was of concern to the airport. Does that sound familiar? Let me see if I can find those.
Thank you for that. And I'm looking at page 31 in the packet, and it's the letter from Samantha Bleimer from Centennial Airport. And then I was also looking at the referral comments. Does staff have any response to that?
We can look in the staff report and see if the applicant provided anything more specific. Our regs do require that there is a note that's placed on the plat. That's sort of, the way the note reads is owner waives, remises, and releases any right or cause of action it may now have or which it may have in the future against the County of Douglas, its officials, and it's related to aircraft and the airspace above the property. Now, of course, that's a note that's on the plat. So, an owner buying a lot would have to look at the plat and be aware, maybe, if they saw that, they would say, what is that? Because it does reference the passage of aircraft in the airspace above the property. So there is a note on the plat. It's not a navigation easement. That's consistent with what our zoning resolution requires.
What does the note on the plat say?
Okay, it says owner waives, remisses, and releases any right or cause of action it may now have or which it may have in the future against the County of Douglas, its officers and employees and agents related to or resulting from the passage of aircraft in the airspace above the property that is the subject of this development plan, this plat. So that'll be on
Yeah.
the recorded final plat. It's not an navigation easement, but it is a note related to the passage of aircraft and, a person, an owner, successor, and a sign of this plat in the lots, is warned that they won't be able to take action against the county for that.
Well, that is helpful. I wouldn't assume that a purchaser is ever going to necessarily look at a recorded plat and say, this is here. But at least there's constructive notice. That would not, I want to keep my Douglas County hat on, but, just thinking through the lens of Centennial Airport, they would not be included in that indemnification, right?
Right, unless they're an agent of, so the county attorney's saying no.
Yeah. Okay. Well, I'll open it up for the further discussion from the board.
I did have one other question, that in one place, this is for the applicant, in one place in the packet, I saw that the density is 0.31 units per acre, and in another place, I saw that it said it was 0.68 units per dwelling acre. Do you know which one of those is correct?
Yes, I believe the 0.68 was a typo. It is the 0.31. Within the PD, there's the 2,043 acres, and there's 968 units included within it.
Okay, thank you.
You're welcome.
And Commissioner Layden, on page 93 of 159, there's a blue box, like I mentioned. It says, comments noted. It does not appear that this property is located in either the runway safety zone or the fan safety zone. The county does not require maybe it's a typo, a navigation easement to be recorded because the property is not within either zone listed above.
Yeah, and I appreciate that. We've been long requested by Centennial Airport Authority to modify our zoning regulation to have some increased attention to this issue, and we have not to date, but I think in many ways we do that to our own detriment. I think what I'm referencing is, in that specific letter, they walk through the noise attenuation issue, the navigation easement, and then they also say that all objects on this site that penetrate a 100-to-1 slope from the nearest point of nearest runway require filing and approval from the FAA. And a Form 7460-1, they say that's a state and federal regulatory requirement. And they also say runway endpoint data. Let's see, in their calculations show that a Form 7460 may be required for both the building and associated cranes. Let me make sure, has that issue been addressed?
Come up during the site improvement plan process for specific structures.
Okay.
So, it's usually when you have to put up a crane to construct something. And so if there's been a commercial building, like the rec center, for instance, if they needed that form, we do usually refer to Centennial for all our site plans and things like that. So I believe it would have come up and we would have gotten it. We don't do site plans for individual homes.
Yeah.
But our zoning compliance staff is pretty good. I think we would be charged to know if we have any structures that exceed that plane. That's something that we would be responsible for.
Yeah. So you think it's primarily cranes associated with
it's
construction?
Usually, even when we
Okay.
get up closer to the airport where, it's
Right.
the angle isn't as big. It's usually been cranes during construction, not the structures themselves.
Got
I think
it.
in Highfield Business Park, it's actually limited the height of certain structures, but more typically, it's cranes.
Okay.
And you have to get a permit for that.
Well, I'm satisfied with that issue for that requirement. I'm also encouraged by the plat note with regard to, the navigation easement issue. I think where I'm still struggling is the interior noise attenuation. And I would ask the applicant, do you have any sense of what that noise attenuation is?
bear with me here. Trying to get a sense of distance. I mean, optically, from our property to the tail south end of the airport, I mean, to me, that looks like 12, 13 miles. You know, the whole phase of Canyons North, Lyric, which is the community in Centennial. I mean, Lyric is like 2 miles away, and they're developing homes under that. Stepping Stone is south of that by about 4 miles south of the airport. Canyons North looks like it's 5, 6 miles, and we're another probably 4 or 5 miles further south. I just think we're so far away that we're not dealing with some of these more rigorous noise issues, flight path angles. I just think we're way far away from, and that's probably why it wasn't pressed as a really serious issue from the authority. That's my gut instinct here on why this has not been, you know, I think I'd be willing, Commissioner Layden, if it's helpful, to include a disclosure on behalf of the developer that is like a one-pager. You are approximately 13 miles south of the Centennial Airport, or Arapahoe County Airport, and we're putting you on notice, just as a heads up. And that can be slotted in with the builder's closing. I mean, we as the developer are building the next 155 lots for 4 builders, 4 national home builders. We'll hand that to them, and they can put that in their closing documentation as a notice, just so that they're aware.
I really
would
appreciate
offer
that.
here today.
Yeah, thank you. And I think that's consistent with the commitment that you all have made and really the wonderful project that this is. So I do appreciate and would accept that. And I don't want to speak to other applicants. My colleagues are well aware that this comes up by me anytime we see an application in or around the Centennial Airport. But I wouldn't disagree that you are more attenuated than others.
Yeah.
I just would hate for a consumer to purchase a home, get into it, and then it's super noisy, and they weren't able to address that in advance. So I guess my original question was whether or not you knew what the noise attenuation was.
I don't.
You don't. And they're recommending at or below 45 decibels. Does staff have any other information on that?
I wouldn't know. We'd have to look at what the construction, type is when they apply for building permits. It has to do with certain types of windows and certain types of insulation on the homes. And I'm just not sure a typical single-family home, what they're constructing to. I
mean, for what it's worth, we built a community in Dallas-Fort Worth that's literally adjacent Love Field. Like, it's like across the highway. And we're talking like a quarter of a mile. And this is 12, 13 miles away. I just don't think it's a big concern personally. I mean, that's just my take. But
well, sir, this is not Texas. And I'll tell you, week after week, we get just a dearth of complaints. Sometimes it's just from the same frequent flyers, no pun intended, but the noise complaints are a real thing and the litigation is real. So I don't want to be flippant about issues that are significant to our community.
Yeah.
But I do appreciate that. Let me open it up for any further questions from our board.
I'll just weigh in about the block that I read on page 93 of 159, and this issue is not, does not rise to the level that I need it put in documents when people close, as one of 3.
You do not?
It does not, based on what this says on page 93, that this property is it does not appear that this property is located in either the runway safety zone or the fan safety zone.
So I would just add, I think because we've heard, fair statement that it's somewhat attenuated from the actual airport. If the concession is to provide some notice to your purchasers about the proximity, I think that would certainly be a positive step in the right direction that I would be willing to accept if the board is.
I might be jaded on this one just because prior to coming to this office, I spent 6.5 years on the Castle Rock Council. I'm a resident of Castle Rock. I would say my residence is actually closer to the line of approach, as we did have, as you did note, Commissioner Layden. And maybe it's my personal anecdotal knowledge on this one, but no, this isn't an issue. And I appreciate you bringing up the concerns that have come out of Greenwood Village. But to the applicant's example, Greenwood Village is within 2-3 miles of anywhere around Centennial. And yeah, we're 15 miles out, easy. And so I don't see this as an issue that should constrain any sort of development in this area. It's just not. Sorry, man. It's been like 9 years that I've heard. And you know, you made a very good point of it is the same people that we hear from over and over again. And I've heard from those same people too in my prior service with the town of Castle Rock, and had an example, a very clear example of going out to a residence, having that resident, we observed an airplane within proximity, and that resident was, beside himself of the noise that it had caused. And I told him then, and I'm willing to say now, that was nothing. That was in no way a high decibel. And so, I don't know. Sorry, man, I'm not with you on this one. I do appreciate you always bringing it up. I do think there could be a time, because of our the county's proximity to Centennial Airport, that it could be germane and it could be applicable. I just, knowing this area the way I do, having traveled Crowfoot Valley Road for many, many times over the 20 years that since I left the Army and took up residence, not interested in pursuing it with this property, particularly with this preliminary plan. I do not think it's germane.
Well, thank you, Commissioner Teal. That's why we have a 3-member board, and I wonder if, Mr. Murphy, this is how we resolved it last time. So I'll continue to talk about it, and maybe we'll continue to go down this path. Let me ask the applicant, are you okay with the 5 conditions as presented? And if staff would like to show those, I don't know if we're at 4 now or 5.
5.
I just want to confirm if.
And sir, you're welcome to approach.
Eric Paddock for staff. There are 5 conditions. We added the all commitments and promises, which is the standard board condition. I can
pull it up.
Yeah, we're good with those 5 conditions. Thank you.
Okay, do you need to see those? Okay. And it looks like the applicant is saying no, and they're okay with conditions as presented. With that, let me open it up for any citizen comment. Is there any citizen comment with regard to this item? Yes, sir.
Hi, my name is Eric Boffman, B-A-U-G-H-M-A-N. I live at 3079 Bivouac Point. I was wondering if I might have that last slide up, if that would be okay with the staff members. Thank you for having me. Thanks for taking the time to listen to this issue. You probably hear this issue all the time from other neighborhoods. It sounds like very common. This is very, very important to me and my family and my neighbors. Me and my wife are Colorado natives. We're born and raised here. My wife is a Douglas County native. We have been looking for the right house, the perfect house. We've lived in 5 houses in 11 years. We have found this neighborhood. My wife, before they even had any roads, was in love with this neighborhood, in love with this spot. And we never, ever would have moved to our location here if we were going to back to another house. We didn't back to another house at our other lot. And yes, Commissioner, to your point, we would be happy to prove what our premiums were versus the neighbors across the street lot premiums were, because we don't have a house behind us. I appreciate Hines saying there's 74 feet. We didn't pay a premium for 74 feet. We didn't move from this neighborhood for 74 feet. 155 houses in this next project that they're going for. I'm just saying, work with us. 8. We're talking about 8 houses. This is a multi-billion-dollar company out of Texas. We're Colorado natives, just asking for them from flexibility for 8 houses. I appreciate him saying we're happy to move 2 of the houses, but again, you all are going to decide that long before we'd ever have a resolution, so that wouldn't really affect us at all. We're just pleading with you, pleading with Hines, to just work on this with 8 houses. That is it. This is a huge development. If you look at the map over here, compared to this is just part of McCanta that you can see. There's a lot of these long roads that end in these cul-de-sacs with open space between them. That's what we love. When we were originally shown from the assessors the plot and what we were shown from our salesman walked out there with us saying, yes, at some point there's going to be houses on top of this hill. We never would have signed if we were shown this. This looks like they shoved in 4 cul-de-sacs. We ran out of space. We have to get our, every dollar's worth out of this neighborhood. We have to shove in these cul-de-sacs. If you just look at those cul-de-sacs on the left hand of the screen, it looks nothing like these long streets ending in cul-de-sacs with gaps of open space. Please just look at this, and this is not consistent with the rest of the neighborhood. This is not consistent with what we signed up for. I never would have signed pen to paper if we were shown this map. So thank you for your time.
Thank you, Mr. Boffman. Any additional citizen comment?
Hello, I'm Lauren Taylor, Taylor. I also live on Bivouac Point, and I'm coming before you because I'm a concerned citizen, a resident, and a mom. Obviously, backing to that cul-de-sac, that development, my kiddos are going to lose their yard for an entire probably 2 years, dust, debris. All of our complaints have been written to you in the public comments, so I'm not going to beat a dead horse. But what I do want to come up with is a solution for homeowners, because we were sold on McCanta as resort-style living, open space. I too, my husband and I are both Colorado natives. It was essential to us that our kids be raised in Colorado, in the environment. We hear coyotes, we see owls, we see elk, we see deer. We're going to lose that. And all we're asking, when Eric referenced 8 homes, I don't know where the clicker is. 8 homes. This is what I'm talking about. If we could just get rid of this cul-de-sac, we are then still getting the open space that we were promised. There's a clear disconnect between Taylor Morrison and Hines. I'm not saying that either one is at fault, but there was a miscommunication. The things that the neighborhood we were promised when we signed, we were going to have an amenity center with a coffee shop, a beer garden, a bike repair shop, 5 miles of open trails for hiking and walking and biking. There was going to be camping. Hines' own website advertises McCanta with a resident building a tent. That we know is not true. So the last thing that residents, at least that we're clinging to, is our open space, because everything else, and I mean everything, was overpromised and underdelivered. I don't know who's at fault for that, but there's some disconnect there. We made the biggest purchases of our lives. We are trying to build our dream homes. We were sold a dream, and we aren't getting it. I'm asking for 8 houses to be reallocated in this vast space that Hines owns. I know it's a money grab. I know that for them, they're going to be in, out, and on to the next project. We are voters. We are taxpayers. We bought into Douglas County. We bought into Castle Rock and into McCanta specifically because it is so beautiful. And that is what I am passionate about. I want my kids to have that. And I cried at the last meeting because I get very passionate about where I live. Hines will be gone. This is our livelihood. Our property values will be sunk if these houses are built. We all know the debacle with property taxes being extremely high. So if I'm now paying sky-high taxes and my property value goes down, where is this? I was lied to. And I believe that the public comment reflects that and everything that people have submitted. So I'm asking the board to just please consider the existing residents. We are concerned, we are scared, we are upset, we're losing sleep. Hines is an international developer. This is a pimple on their radar. This is everything to me, everything to them. So I do ask that you please consider that. Thank you.
Thank you, Ms. Taylor. Additional citizen comment? Yes, sir.
My name is Justin Panetta. Last name's Pennetta. I wanted to start, I guess, maybe in opposite direction to at least thank Hines. Without you guys, we wouldn't have the homes we have right now. So the effort you've put in and given us this opportunity, I do want to say thank you. I know this isn't easy for you guys. It's not easy for us. I think our neighbors would agree it's not personal. So I would like to start there. To the point, it's developer versus builder. Commissioner Thomas, you brought it up. We were charged an extra premium. Don't really want to beat that up. It would be very easy for us to go back through and show that we paid almost double, excuse me, what neighbors across the street have paid. The records, if you've pulled them now, they weren't in any of the slides, but from your guys' the assessor page, you can see the plot lines that are there now. It's 4 cul-de-sacs that are being added in. It's frustrating because, as a home buyer, you do your due diligence. It is a big purchase, the biggest purchase you'll make of your life. We're just asking that as the neighbors that have helped Hines make this community a great community, to not make it at our expense. You're talking about extra parks being added in. The current neighborhood has 1 park. If you look at this map, there's 4 other parks going in, 2 houses that aren't even built yet. We have 1 current park. You're talking about 3 net acres of open space. Again, you're talking about at the expense of the current residents. And I think, to our neighbor's point, whatever maps we're showing, we're going to go off county records, what we find, what we see. We did our due diligence. These are plotted maps. These have addresses right now. They're asking to change those. Again, it's a small piece of a large project where, again, it's going to affect us for the rest of our lives, the rest of the days we're in this home. There's 2 really large parks across the street. I'm not a developer. I don't know how hard it is to replot homes, but it seems like there is some wiggle room in where some of these houses can go, again, to help satisfy everything that we're asking. Again, it's a great community. We want to keep it a great community. And the people that have helped make it that way, we don't want it to be at our expense. That's really all we're asking for as neighbors, as a community, that we could kind of work together and find a middle ground in however this is going to be redeveloped. And I think, we've expressed that today. So thank you guys for your time. And, again, thank you guys for our opportunity.
Thank you, sir. Appreciate it.
Yep.
Yes, ma'am. Any additional citizen comment?
Good afternoon, Commissioners. My name is Matt Valente. I live at 3118 Bivouac Point. I'm a little torn on how to approach this. I'm scratching my head a little bit because, again, everyone approaches home buying a little bit differently. When I was doing my due diligence and buying my home, I relied mainly on the information provided by the developer, Hines. The marketing website for the community is livemacanta.com. And so I was going back, I read the comments from last week's Planning Commission, and I was a little bit confused. I went back and I looked actually at an archive of a sales map presented by Hines, livemacanta.com, from the very end of 2020. I compared that to a map from this morning. Looking at that map, what I saw was there was a lot of changes across the board. Obviously, it's a very big project. I'm sure a lot of challenges and complications from an engineering planning standpoint as far as where these lots can go. This area here was exactly the same from 2020. So again, with all due respect to my friends and neighbors here, who I do have a great bit of respect for, I always relied on this map, and to me this is no different than the day I signed my contract. I understand it's a little bit different for me. I'm out on the other side of the road, so I'm not as directly impacted by the lot shift. But in my mind, I believe that Hines is, while not perfect, the community is beautiful, and I believe they've done a good job of representing what they've said they're going to build. My bigger issue, and I just want to take a brief moment to say, this has been a very confusing and very painful process in terms of just the way that the planning has been done for this community. For those not keeping score, this is the 3rd PD amendment in 3 years. Obviously, there's been a master plan vision from the beginning, and it seems weird to keep jumping through these hoops and having these hearings to hit this plan. Obviously, it's created a ton of confusion. There's mismatch between the assessor and the old plat and the new proposed plan. If this could have been done up front in a more simplified manner, I think it would have created a lot less confusion for everyone and less heartache. I really appreciate Chad's proposal to shift these lots further away here. I think that amount of space, if they are able to relocate those 2 lots, that's a meaningful amount of space. I think that goes a long way, so I appreciate that proposal. And just a final point, Commissioner Layden, for the record, I've never heard a plane from inside my house, if that helps you feel better. That's all I have. Thank you.
Thank you, sir. Any additional comment? Any citizen comment online?
Yes, sir. I do have one online comment. Hold on just a moment. Oh, I'm unable to unmute her. Oh, there you are. Sarah, you're unmuted. Go ahead.
Hi, can you hear me?
Yes, we can.
Yes, we can.
Oh, perfect. Hi, everyone. My name is Sarah Baughman. That's Baughman. I am a resident on Bivouac Point. My family and I are homeowners on Bivouac Point, and our home currently backs to the current open space that is being further developed under the amended plan. My husband and I searched over the course of 2 years for our forever home, and a must-have for us was a backyard that backed to open space. We are Colorado natives, and we truly do value the beauty and nature that our state offers. Before deciding to move forward with our lot in McCanta, we reviewed in detail the plans that were presented to us by the builder, knowing that there would eventually be development behind us. Now, we relied on the official approved plans. This Live McCanta map and site that we've been shown has changed many times. None of that was included in our contract documents. What we were shown in our contract documents were houses in the distance up on the ridge, nothing about these additional cul-de-sacs. And as, purchasers, we were going by the, plans that were shown to us. We knew that there would eventually be that development behind us, but it would be in the distance, not eating into the open space directly behind our home. We paid a premium for our lot based on the open space, and the builder assured us that even with future development, we would retain substantial open space behind our home, even if plans were to have slight changes. We're not dense. We understand that, there can be changes to plans over time. But as you can see, this is an extremely substantial change that we never would have imagined. It's evident that the intent was to pile in as many houses in this area as possible, with all of these offshoot cul-de-sacs that are not consistent with the design of the neighborhood. And while Hines has stated that this change increases overall open space within the entire community, it essentially eliminates the large portion of open space behind our home, which would undoubtedly interrupt the wildlife activity in our area. Last week at the meeting with the Zoning and Planning Commission, Hines expressed that they were sympathetic to our pleas, and that they were sympathetic to what we were sold by the home builder. If that is indeed the case, and they are truly sympathetic and want to do right by their homeowners, we are just asking for a small compromise to relocate the 8-house cul-de-sac that would eliminate the open space behind our home. 8 homes is the difference between us retaining our open space and wildlife, as well as retaining our property values and not backing directly to neighbors. We feel like 8 homes is little to ask and a small compromise on their part, and we really hope that this can be considered. Thank you so much for your time.
Thank you, Ms. Baughman. Any additional citizen comment online?
I have no additional online comments, sir.
Okay, thank you, Troy. And with that, I'll close citizen comment and ask the applicant if there's any response to citizen comment.
Chad Murphy again. I'll just respond by saying we are committed to looking at what we discussed earlier at the final plat stage. And of course, it's contingent upon the Douglas County School District working with us on moving those 1 or 2 lots, but that's what I can commit to at this point in time. I do take some of the comments to heart in the sense that we intend to do what we say we are going to do, and I feel like we've done that throughout this community. I think largely it's been an enormous success. There will still be an open space behind these houses and in between the future cul-de-sac and the existing houses with a trail, as you can sort of tell there with that line that's drawn between them. So they are still open space lots. Sounds like there was certainly some confusion, and I am, again, sympathetic to that. And that's why we've put forth the commitment to studying whether we can shift some of those lots further north. we are not willing to remove the lots. Believe it or not, given the current planning area boundaries, there aren't any other locations to move the total 968 lots because there's so much open space outside of the PD planning area boundaries, which is designated in red. And you can see in red as well, it's pretty suggestive of what development was to be contained, even by some of these nuances of the juts and jags around here. So we're adhering to the PD again, and we'll do everything we can to potentially move those lots north. And I'll leave it at that.
Okay, thank you, Mr. Murphy. And I'll bring it back to the board for any further discussion and or motion.
If I could just read part of a sentence that is under the criteria that we need to look through. If this proposal meets all of the criteria, we're required to approve this. So under 403.02, there's a section of 404.03 that says the lotting pattern is consistent with the PD. Proposed open space tract C, which is what I think Mr. Murphy was just referring to in the map, provides separation between the proposed residential lots and the existing lots to the south. So based on the criteria that I've read earlier, and again rereading it and seeing this exact wording in this section, I do believe that the criteria are met by this proposal before us.
Thank you, Commissioner Thomas. Commissioner Teal?
Well, I concur with my colleague. The reality, again, I've been handling development issues like this for the better part of the last 9 years, and I feel for the residents who, have told us today your experiences in purchasing your homes and what you felt you could count on as a commitment. But guys, you can't ascribe ownership to property that isn't yours. And the reality is this is property that does belong to Hines. And I've heard people talk about the pursuit of the almighty dollar, pursuit of profits. That is the point of what they do. That is who they are. They are land developers. And we all get jobs, right? I guess I do have a job, and thank you for being a taxpayer and paying my salary. But before I got here, I was working in business also. So the reality is we need to, part of our job is to understand who has ownership of what properties. And again, I feel for you guys. I do not doubt your stories at all. But at the same time, guys, you cannot ascribe ownership to property that it's not actually your own. With that said, if it pleases the board, I do have a motion to approve Canyon South Preliminary Plan Number 2 because it does meet all the approval criteria with the 5 conditions as presented, project file SB 2023-010.
I'll second that, and I do have a comment.
Please.
So when I opened up this discussion asking about what I had read from the citizens, that they had been promised things, I was trying to determine if there was any responsibility here in this room. And based on everything I've read here and the criteria, I don't think there's anything that this board did or we did here that contributed to this conversation. I don't know if you all have further conversations with Taylor Morrison to figure out what happened, but that is why, after reading all of this carefully, I am in support of this process.
Thank you for that. So it is challenging because it seems as though there were some representations allegedly made by a developer that is not before us today, and that there may be a cause. I don't want to put on a lawyer hat here, but obviously we need to deal with simply the applicant that's before us today. That said, I am deeply sensitive and cognizant and want to be responsive to the needs of Colorado residents, natives, citizens that have spent their, not only their precious time with us in the middle of the day today, but also for these homes where they're raising their families. That is deeply significant to me. And what I heard from the applicant was a concession and an offer to study the area in question to determine whether or not additional compromises can be met. So I don't want to fail to recognize that offer and accept that concession if that's something that the board is interested in. So because it was offered by the applicant in response to citizen concern, the applicant did not have to do that. And I think it was magnanimous to present that as a potential option for these neighbors. I hope it's not just lip service, and I don't believe that it would be. I think it's a sincere attempt to identify a solution in the future before final plat. So as one commissioner, I would be certainly willing to accept that as part of the commitments made by the applicant today, if there's board support for that.
And the commitment was to study it, not to make it happen.
Right.
And I would be fine with that.
Oh, as would I. As a matter of fact, I mean, let's bear in mind where we are in the process here. This is the preliminary plan. The applicant still needs to come before this board for platting, where the studying the moving of the two lots would be memorialized and would be placed into code. So I guess, how do we memorialize that commitment? They've committed to doing a study. It is certainly something that we can give direction to staff to make sure is brought back before the board at time of plat. Does that scratch the itch that we're looking for?
It does for me, and I started out in our planning department as a planning commissioner, so I have a lot of respect for the people at that dais over there, and I know that they will ensure that this is part of the process and that we see it at final plat. I don't know if staff has any additional comment on that.
We won't forget.
You guys are so good. So that would satisfy me, and if that is the case, then I would be in support of your motion.
Okay, and then just as an advisory to the applicant, that does mean that we will be expecting to see the results of your study come plat. Now, obviously, you'll have the opportunity to do the application and present it on its own merits at that time, but I think it's fair warning to the applicant that you have made a commitment to take a look at it, and those will be questions that will be coming from the board at time of platting.
So any further discussion?
If I may just ask a clarifying question of our county attorney, I don't know if we're out of our...
A bit. We're asking if there's further discussion, but I'll entertain it.
Just to clarify this condition, so our understanding is the final plat is an administrative approval and would not actually be coming back to the board for approval itself. So is the board's request to receive an update from the applicant on the relocation, potential relocation of lots?
The final
or
plat
no?
will come back.
The final plat does come back, yeah.
Okay, sorry, thank you.
Sure. Anything else for legal? Okay. Any further discussion from the board? All those in favor signal by saying aye.
Aye.
Aye, and that motion carries 3-0. So with that, the next land use meeting, public hearing, will be held on Tuesday, November 7th, 2023 at 2:30 p.m. We are adjourned.